Thank you for your attention. This is How to Stop a Ninja on the Internet, the No Jobs edition, brought to you by Facebook.com, Hip Hop Lawyers, aka Hip Hop Legal. Yep, this is what's taking place at the grassroots level. It's something similar to a T-word simulation. What does that mean? The billions of dollars that were allocated for the prevention of a September 11th, 2001 scenario, if you get my drift, is being steered towards community policing. So this has created a sandbox-like environment as it relates to the plight of various individuals who have been placed on the TSDB, that is the terrorist screening database. And that sandbox-like environment is very much like the movie Minority Report, except with a strategically placed apparatus consisting of individuals tasked with nudging the targeted individual and do so as a use case in conjunction with predictive policing. That kind of scenario entices individuals to bring out the worst in a particular targeted subject to continue the status quo that they are comfortable with, or to just use as a means of getting paid. In that context, it stands to reason that the consensus would likely be you can't allow the targeted individual to succeed in a way that would effectively stop what could impact and expose your participation. Therefore, it would behoove you to keep the targeted individual going through that proverbial revolving door of failure. One of the ways that this is done is by cutting off or limiting the ways that a targeted individual can gain employment or have access to employment. Here's how it's done. Let's look at it through a legal lens. Manipulating job board visibility to systematically prevent someone from accessing employment would fall under unethical and illegal digital discrimination. That said, if we were analyzing such tactics for cybersecurity awareness, research into algorithmic bias, or understanding digital suppression techniques, we would break it down into methods adversaries might use and how one could detect and counteract them. Potential methods of job listing manipulation. If an entity sought to suppress job opportunities for a specific individual, they could employ a combination of algorithmic filtering, real-time data manipulation, and tracking technologies to make job postings appear and disappear. Below are potential methods an adversary could use. Number 1, IP-based job board censorship. Jobs would be visible when a general user accesses the site. But once a targeted individual's IP address is detected, the listings dynamically disappear. This could be executed using geofencing, IP blacklisting, or device fingerprinting. Number 2, account-based suppression. If the job board requires login credentials, a hidden flag in the database could prevent job postings from appearing to the target's account, even if the user logs in from another device. The suppression remains tied to their credentials. Number 3, real-time algorithmic removal. Jobs are displayed when the user first searches, but upon interacting with the results, clicking, scrolling, a server-side event triggers a refresh that hides all listings. Implemented using JavaScript, AJAX calls, or WebSocket listeners. Number 4, shadow banning through personalization. Job recommendations are typically based on a user's profile, skills, and past searches. A suppression system could skew the algorithm to intentionally match the person with irrelevant or expired listings, making it appear that there are no suitable jobs. Number 5, AI machine learning based filtering. Machine learning classifiers trained on the user's activity could flag them for exclusion from employer searches or block their applications. Employers might never even see the person's resume. Number 6, browser fingerprinting and cookie manipulation. A job board could use persistent tracking cookies and fingerprinting, analyzing browser type, operating system, screen resolution, to recognize the user, even if they change accounts or IP addresses. When the system detects the target, it removes job postings or introduces artificial errors, quote unquote, such as, quote, no jobs found, close quote, messages. Number 7, API level job filtering. Many job boards pull listings from external APIs. A censorship system could filter what is served to a specific user's session ID, showing blank or outdated postings. How to investigate and document this. If you want hard proof, you'll need to take investigative steps to catch the system in action. Number 1, screen recording and network monitoring. Next time you search, record your screen using software like OBS Studio or built-in screen recorders. Open developer tools in Chrome, Microsoft Edge, and Firefox. Click on F12. Go to the Network tab, refresh the page, and watch if job listings are being actively hidden or deleted in the background. Capture evidence of HTTP request being blocked or manipulated. Number 2, check from another location or device. Try a different Wi-Fi network. Home versus mobile hotspot versus VPN. Search on a fresh browser with cleared cookies and compare results. Ask a friend to search the same query simultaneously from a separate IP address. Number 3, use a VPN or Tor browser. If jobs appear when using a VPN or different browser, you have hard evidence of IP or identity-based suppression. Number 4, API scraping to compare results. Some job sites allow direct API queries or can be scraped via Python. If job postings exist in raw data but are missing in your interface, this confirms manipulation. When documenting and or testing a theory, consider and analyze who would have the means, motivation, and opportunity to execute such digital suppression. Let's break it down into each potential cause and the level of sophistication required. Number 1, IP-based suppression. Blocking access based on your internet connection or device fingerprinting. Who can do this? Website administrators or third-party contractors. The various IT departments or any third party managing a website could blacklist your IP address or device using web filters, firewalls, or access control policies. If a particular job board operates on cloud services like AWS, Azure, or Google Cloud, administrators could apply geofencing rules, user agent filtering, or behavioral triggers to block content from appearing for certain users. Internet service providers, ISPs, such as Comcast, AT&T, T-Mobile, etc. Your ISP has full control over your internet traffic. If flagged An ISP could route your job search request to a proxy or null endpoint, making job listings disappear when you access certain sites. Some ISPs work with law enforcement or corporate interest to throttle or alter content access for specific users. Government or private surveillance entities. If you are on a form of watch list, counterintelligence radar, or corporate quote unquote problematic list, intelligence agencies or private contractors could interfere with web traffic. Such entities as fusion centers, predictive policing systems, or private security firms have the technical ability to monitor and manipulate what you can see online via network level interventions. Number 2, AI-driven blacklisting. Algorithmic filtering based on past behavior, applications, or flagged activities. Who could do this? Job board algorithms. Many job boards personalize results using machine learning, ML. If your searches or applications have been flagged as high risk, politically controversial, or undesirable, an automated bias filter may be excluding jobs from your view. These systems rely on user profiles, application history, social media data, and even credit scores to rank and limit opportunities. Background screening companies such as LexisNexis, Hire Right, Checker, that's CHECKR, etc. These firms aggregate employment data, criminal records, financial activity, and social media behavior. If an employer has blacklisted you or entered you into a quote unquote do not hire system, AI-driven job platforms may hide jobs from you automatically. Some firms sell risk profiles to HR teams. If flagged, the system could remove jobs before you even see them. Corporate government watch lists, threat assessment programs, private blacklist. If you have challenged authority, sued a company, or been vocal about certain topics, you may be in a private sector risk database. Examples include Palantir, Clear, IBM i2, Analyst Notebook, and DHS fusion centers that track individuals of interest. Number 3, traffic interception and manipulation. Live sabotage of your web experience, making jobs disappear mid-search. Who could do this? Law enforcement intelligence agencies, or national security groups. If targeted by predictive policing, gang stalking, or COINTELPRO style operations, agencies like the NSA, FBI, DHS, or local fusion centers could intercept and alter web traffic. They have deep packet inspection, DPI, technology that can modify live content as it loads on your device. State-sponsored cyber programs. Pegasus, X-Keyscore, Palantir. If considered a quote-unquote person of interest, advanced surveillance tools could interfere with real-time browsing, injecting or deleting content before it renders on your screen. Programs like Pegasus spyware, Fisher, and NSA Quantum Insert are capable of dynamically altering search results based on user metadata. Corporate and private security firms, threat intelligence, hack for hire groups, Fortune 500 companies, and universities sometimes hire private security firms like Black Cube, Kroll, that's Kroll, or Securitas, that's Securitas, to target employees, students, or whistleblowers. If a particular corporation has flagged you as a quote-unquote disruptor, a private security firm could deploy network filtering tools against you. Key indicators of targeted digital suppression. Number 1, inconsistent results across devices and networks. If you get different results on a VPN, mobile hotspot, or someone else's Wi-Fi, your suppression is likely IP-based. Number 2, jobs appear and then disappear in real time. This suggests live traffic manipulation, possibly via a script or external interference. Number 3, strange browser behavior, redirections, timeouts, errors. If the site refreshes, lags, or jobs vanish when you click, this could indicate JavaScript injections or API filtering happening at the server side or network level. Number 4, your job searches and applications seem unusually rejected. If companies never respond, or your applications go into a black hole, your data may be flagged in a do not hire registry. What can be done? Number 1, test your theory. Use different devices, browsers, and networks to confirm suppression patterns. Ask a friend and compare results. Number 2, monitor network traffic, deep packet analysis. Use Wireshark or network logging tools to detect unusual packet drops, redirects, or injected scripts. Number 3, use scrapers at your discretion to compare public versus private job listings. If the data exists in APIs but not on your screen, this confirms selective filtering. Number 4, legal options. Freedom of Information Act, employment rights, digital discrimination. Depending on the severity of suppression, you may have grounds to request records via Freedom of Information Act, GDPR request, or employment discrimination laws. If entities are involved, then they may be violating federal but also state employment laws by blocking access. The tactics we've gone over are just like COINTELPRO, digital redlining, and even algorithmic bias. The frustration elements that are embedded in these processes amount to psychological warfare. And it would appear that the goal is to induce learned helplessness and self-doubt. Again, capture proof, and if you have someone that also witnesses this, it gives you more credibility. As it relates to the affiliates who are involved in blocking, filtering, or manipulating one's access to employment opportunities, there are multiple legal theories under which they could be held liable for damages. Number 1, employment discrimination and economic harm. Tortious interference with prospective economic advantage. If an entity intentionally obstructed one's ability to apply for jobs, they may be liable for damages under this tort. Damages: compensatory, lost wages, loss of future earnings. Punitive, if intentional discrimination is proven. Violation of the Fair Credit Reporting Act, FCRA, if blacklisted. If any of the entities use third-party background check systems, e.g., LexisNexis, HireRight, to unfairly filter you out, this could violate the FCRA, which mandates transparency in employment decisions. Damages: $1,000 per violation, plus actual damages for lost income. Number 2, digital and constitutional violations. First Amendment violation. If we're talking public institution and they suppressed your job access due to protected speech or viewpoints. This could be unconstitutional, as state-funded institutions are not allowed to do this. Damages include injunctive relief, forcing the institution to fix their system, monetary damages for lost opportunities, and emotional distress. Computer Fraud and Abuse Act, CFAA, digital manipulation or interference. If a system was actively modifying or intercepting data to make jobs disappear, this could qualify as a violation of the CFAA if done maliciously. Damages include civil penalties for unauthorized computer interference, additional damages if economic harm resulted, consumer protection violations, deceptive business practices. If a website falsely advertised open job positions but removed them from your view, this could be deceptive trade practice under the Florida Deceptive and Unfair Trade Practices Act, FDUTPA. Damages, financial penalties, actual losses from job opportunities. Number 3, psychological and emotional distress. Intentional infliction of emotional distress, IIED, if a company's actions were deliberately meant to frustrate, harass, or cause distress, one could argue IIED. Damages include emotional suffering, loss of enjoyment of life, negligence, failure to maintain access. If a job board's algorithm or IT system were faulty and caused job listings to disappear due to negligence, one could argue that they failed their duty to provide fair access. The damages for this includes lost job opportunities and professional setbacks. Now let's talk about corporations specifically, because here is where the damages can range in the millions of dollars depending on the extent of harm. Number 1, economic and employment law violations, tortious interference with prospective economic advantage. If a corporation intentionally blocked or filtered job postings when searched, it could be liable for interfering with one's career prospects. Key factor: evidence that the corporation selectively obstructed your access, while others could see and apply for jobs. Damages: lost wages and future earnings. Compensation for income you would have earned. Punitive damages: if the corporation acted maliciously. Employment discrimination, Civil Rights Act violations. If a corporation filtered jobs based on race, age, gender, political views, or protected characteristics, it could be violating Title VII of the Civil Rights Act and state employment laws. Damages, back pay, front pay, emotional distress damages. Possible class action if multiple individuals experience the same issue. Violation of the Fair Credit Reporting Act, FCRA, blacklisting practices. If a corporation is using background checks or AI algorithms to suppress your job visibility, it might be in violation of FCRA, which mandates fair employment screening. Damages $1,000 US per violation, plus actual damages, lost job earnings. This corporation could be forced to disclose all data about you. Number 2, digital and antitrust violations. Computer Fraud and Abuse Act, CFAA, unauthorized manipulation of data. If a corporation's system altered job postings in real time when you access them, it might violate the CFAA, which prohibits unauthorized data interference. Damages include civil and criminal penalties, and this corporation could be forced to pay compensatory damages for economic harm. Antitrust violations, restricting market access. If a corporation deliberately restricted you from seeing or applying to jobs to limit competition or maintain control over hiring pools, it could have violated antitrust laws such as the Sherman Act and Clayton Act. Damages, treble damages, triple actual losses if antitrust violations are proven. Possible federal investigation into that corporation's hiring practices. Number 3, consumer and contractual violations. Breach of good faith and fair dealing. If the corporation's hiring practices are deceptive. If said corporation publicly posts job listings but systematically blocks certain people from applying, it could be sued for bad faith hiring practices. Damages include compensation for misrepresentation and lost opportunities. Next we have Federal Trade Commission, FTC violations, deceptive business practices. If a corporation advertises jobs to the public but secretly removes them for certain users, it could be engaging in deceptive practices. violating the FTC Act. Damages, fines of up to 43,208 US dollars per violation. Injunctive relief, forcing said corporation to change its policies. Number 4, psychological and emotional distress. Intentional infliction, again, of emotional distress. IIED. If said corporation's actions were deliberate and designed to cause distress, one could claim IIED. Damages include emotional distress compensation, loss of career opportunities, negligence, failure to maintain fair access. If the corporation's hiring system or job board algorithms were faulty, causing job listings to disappear unfairly, they could be sued for negligence. Damages, lost job opportunities, and reputational harm. When it comes to holding corporations accountable for antitrust violations, which could be knowingly or unknowingly participating in market restrictions or discrimination in hiring, they could be sued under antitrust law. Legal grounds to sue corporations. The Sherman Antitrust Act, 15 USC 1 through 2. Section 1 prohibits companies from entering into agreements that restrain trade. For example, colluding with law enforcement to block certain individuals from job opportunities. Section 2 prohibits monopolization and exclusionary practices that limit economic participation. Clayton Antitrust Act, 15 USC, Section 12, expands liability to corporations engaging in coordinated efforts to deny employment based on blacklist, hiring discrimination, or algorithmic filtering. Federal Trade Commission Act, 15 USC, SS 41 through 58. Corporations that enable, permit, or ignore hiring manipulation could be deemed as engaging in unfair methods of competition. Here's how to prove the corporation's liability. You need to gather evidence that shows a pattern of obstruction, that is, repeated instances of job postings disappearing when you access them. Selective restriction. Other people can access opportunities that you cannot. Coordinated with external factors. Evidence that law enforcement, surveillance entities, or private security groups are influencing hiring systems. Steps to hold corporations accountable. Number 1, demand transparency. File a quote-unquote right to know request under GDPR/Section CCPA. Demand that any corporation or companies disclose all data about you, including job search history and algorithmic decisions. If they refuse, this becomes evidence of concealment and strengthens your case. Also, file an FTC complaint. Submit an antitrust complaint to the FTC, demanding an investigation into algorithmic hiring discrimination and collusion with external entities. The FTC can issue hefty fines and force corporations to change policies. Contact the Department of Justice Antitrust Division. The DOJ investigates corporate collusion and can prosecute companies and government entities engaging in hiring discrimination via algorithmic filtering or law enforcement manipulation. Number 2, holding law enforcement accountable for antitrust violations. If law enforcement agencies, local police, federal agencies, or private security contractors are colluding with corporations to suppress your economic participation, they could face civil rights and antitrust liability. Legal theories to use against law enforcement. 42 U.S.C. 1983. Civil rights lawsuits against government officials. Law enforcement officers and agencies cannot conspire to interfere with your employment under color of law. If they are using technological tools, surveillance, or pressure on private companies to restrict your market access, they are violating your civil rights. You can sue them individually and as an agency. The Sherman Antitrust Act. Law enforcement's role in market suppression. Law enforcement entities that coordinate to block your access to jobs are engaging in quote unquote group boycotts, which is a violation of Section 1 of the Sherman Act. Government actors are not immune from antitrust violations if they are acting outside their official duties. RICO Act. 18 U.S.C. Section 1961. If there's organized suppression, if multiple agencies and private companies are collaborating in a coordinated effort to blacklist you, this may qualify as racketeering activity. RICO lawsuits can result in treble damages. Again, triple the actual loss. Steps to hold law enforcement accountable. Step 1, demand public records. Submit Freedom of Information Act requests and Sunshine State law requests to law enforcement agencies. Demand emails, logs, surveillance reports, and any communications with private companies that may have influenced job restrictions. Step 2, file a civil rights lawsuit. File a 42 U.S.C. Section 1983 lawsuit against any law enforcement agency involved. Seek injunctive relief to stop ongoing market restrictions. Demand monetary compensation for lost earnings and punitive damages. Step 3. File an antitrust complaint with the Department of Justice. The DOJ Antitrust Division investigates government actors engaging in anti-competitive practices. Submit a formal complaint outlining pattern of job restriction, evidence of collusion with corporations, potential discriminatory intent. Step 4. Congressional and media exposure. Contact investigative journalists and congressional representatives. Push for congressional hearings on algorithmic employment suppression and law enforcement interference in market access. Number 3. Potential damages you can claim. Treble damages. Antitrust violation penalty. You can recover 3 times the financial losses suffered due to job suppression, lost wages, and future earnings. Compensation for jobs you were blocked from applying to or securing. Emotional and psychological distress. Damages for stress, humiliation, and reputational harm caused by market restriction. Punitive damages. If there is evidence of intentional market sabotage, courts can impose extra penalties to punish wrongdoing. Number 4, high-level strategy. Collect evidence and patterns of suppression. Expose corporate and law enforcement collusion. File federal complaints. DOJ Antitrust, FTC, EEOC, and Freedom of Information Act requests. Pursue lawsuits and seek damages for lost economic opportunities. And finally, leverage media, investigative journalists, and Congress for oversight. Yo, don't let them play with you. Straight up.